and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, good morning, everybody. Welcome to this remote session of court for the United States Court of Appeals for the Fourth Circuit. We have three cases on for hearing this morning. First up, 25-2087, Fairfax County School Board versus Secretary of Education Linda McMahon. Mr. Heafy, I hope I pronounced that right. Whenever you're ready.
Heafy with a long
Heafy. All right. Whenever you're ready, sir.
Thank you, Your Honor. May it please the court. I am Tim Heafy. I'm here from the firm of Heafy, Smith, Harbach, and Wyndham. I represent the Arlington Public Schools and the Fairfax County Public Schools. Your Honor, we initiated this litigation back in August of this year because of an underlying policy dispute that our clients have with Secretary McMahon, the defendant Department of Education, over the school's policy providing access to facilities based on gender identity. Our clients believe that that policy is consistent with the Constitution, the Equal Protection Clause, Title IX, and this court's precedent in Grimm and affirmed recently in Doe. The defendants disagree with that and have issued a letter of findings and a high-risk designation alleging that the school's policy violates Title IX. We're not here today, Your Honor, to ask Your Honors to adjudicate that policy dispute. We are here to talk about where appropriately that policy dispute should be litigated. But it's important to start with the policy dispute because it informs that question as to where this case should be litigated: in the district court pursuant to the Administrative Procedures Act or in the Court of Federal Claims consistent with the Tucker Act. I want to start, if I can, with this court's recent opinions in the Sustainability Institute case and solutions in homegrown connections, because they had talked about that line between the APA and the Tucker Act. Our case differs from those two clear precedents of this court in three significant ways. First and foremost, this case does not involve a termination of funds. There have been no funds yet withheld from Fairfax County or Arlington Public Schools. What has happened, Your Honor, is that the department, as I said, issued a high-risk designation based on what we purport is an incorrect interpretation of Title IX. They have said you can only get federal funds by reimbursement, and significantly, and this is the key portion of the high-risk designation letter, they impose conditions on continued availability of those funds. They say
Mr. Heafy, can I interrupt? Sorry to interrupt you,
yes,
but
please, Your Honor.
I appreciate the update with respect to the fact that there have been no funds that have yet been terminated, but I suppose that's possibly in the offing down the road. Would the result of this case be any different if there had been funds terminated, or would you still be arguing that the district court had jurisdiction over some aspects of this case?
Yes, Your Honor, we would still be arguing that the district court had jurisdiction over some aspects of this case. The prospective application of Title IX, what courts have done since the Supreme Court's emergency docket decisions has essentially bifurcated claims and said claims for retrospective relief, the reimbursement of funds previously allocated, should go to the Court of Federal Claims. But prospective direction to the government as to interpretation of law should continue to stay in the district court. So we would
okay. So let me ask you about that. So is that result consistent with our recent precedent, in particular sustainability, which of course the author of that opinion is here today, so she can correct you and I if we're wrong about that. But do you think that divvying up the case in that way is consistent with that precedent?
Yes, Your Honor. I think it's entirely consistent with that precedent because, again, that precedent did not involve a fundamental interpretation of law. The Sustainability Institute case and then the second Solutions in Homegrown Connections case involved categorical termination. The only law to be determined by the court in that case was the provisions of the grant agreements themselves, the actual contract between the plaintiff nonprofit organization, grant recipients, and the government. That's fundamentally different from what's at stake here, right? There's no question that our clients have been.
Can you talk about the difference? You seem to be trying to draw two distinctions there. One, before the chief started asking questions about whether it's prospective or retrospective. But then you seem to transition away from that because I think for good reason, into one about whether it's a legal interpretation or not. Can you separate those two for me? Which are you arguing, or are you suggesting sustainability is distinguishable both because nothing in Sustainability Institute was prospective and nothing in Sustainability Institute involved law?
Both, Your Honor, exactly. Both of those facts, the fact that Sustainability Institute involved grants that had already been terminated and the plaintiffs were seeking repayment of those grants, that's one.
Prospective, but that's prospective relief, right?
That's retrospective relief because the funds had been withheld and the plaintiffs were asking for essentially repayment of something that had already occurred. Nothing's been withheld.
So your position is Sustainability Institute, and you could say the same thing about DOE and NIH, that all they sought were retrospective payments. They were not seeking continued payments of the grants in future months. That all they wanted was retrospective relief. That your position is that all of those cases involved, in effect, retrospective damages and not a command to perform the grants going forward.
That's right, Your Honor. My understanding, and this is true in these cases across the country, is that the courts that have sent these cases to the Court of Federal Claims have said all that's before the Court of Federal Claims is a contract obligation, whether or not these amounts are owed. Prospective determination is not affected by the litigation involving the retros. That is fundamentally a separate question that goes elsewhere. And since the Supreme Court shadow docket cases, the case in California, it's the California case itself, which is being.
Just so that I just want to make sure I understand your argument. Hypothetically, except that I disagree with the premise that those cases were not purely retrospective, can you just articulate in this hypothetical world where that was wrong, what the second argument that you're making is and how it's distinct?
Yeah, Your Honor, I guess the best way to do that is to call your attention to what happened in the California case, the California versus Department of Education case. That is the case that on remand, after the Supreme Court's emergency docket case, was sent back to the trial judge, where the Supreme Court said, hey, these retrospective claims you are making belong in the Court of Federal Claims. The trial judge in Massachusetts, in California, said, I'm not going to adjudicate those claims for pre-existing grant obligations which have been withheld, but I'm going to keep jurisdiction and continue to contemplate resolving whether or not the underlying source of law does or does not prospectively give rise to further claims. So she bifurcated. The retrospective claims go to the Court of Federal Claims. The prospective claims stay within the district court for jurisdiction. That's essentially the rule I'm asking this court to adopt because it is logically consistent with the shadow docket, California and NIH case, as well as the two Fourth Circuit cases.
Mr. Hafey, I appreciate that. I want to take you back to Bowen because this whole thing seems to be that the recent cases seem to put a gloss on Bowen, and without expressly overruling it, it seems like the law has changed. Because as I read Bowen, the court seemed to be pretty clear that if you're talking about if you're seeking reimbursement for grants, in that case I think it was Medicare or Medicaid grants that have not been paid, that's not quintessentially a contract damages claim, but is something else. And because it's something else, both it and the prayer for prospective relief are properly in the district court. We seem to have moved away from that now to sort of bifurcate claims depending on what sort of relief is being sought, which frankly I think is a little bit confusing and not, but be that as it may, we're bound, I suppose, by whatever the Supreme Court has said since Bowen. But why isn't it the case that a judgment in the Court of Federal Claims entitling you or any other entity denied grant money would not have res judicata or collateral effect with respect to any prospective relief? Why isn't that the proper remedy?
Yeah, Your Honor, we do not believe that the Court of Federal Claims would have jurisdiction in this case Despite Judge Alston's finding that this case should have been filed in the Court of Federal Claims, we don't believe that the Court of Federal Claims could contemplate this case. A, there is no privity of contract between Fairfax and Arlington and the Department of Education. These are grants, much like those in Bowen, where the federal government provides money in a formula to states. And
But hasn't the Supreme Court subsequently said that that's a distinction that doesn't matter? It may not be a pure contract in the commercial sense, but it has all the indicia, this grant process has all the indicia of a contract. It's contract-like, and that's enough for its purposes.
Yes, Your Honor, the grants at issue, again, in the shadow docket cases were direct grants to the individual entities, the states and the plaintiffs in those cases. Again, we are in a pass-through situation from Virginia, and the Supreme Court shadow docket cases did not overrule Bowen. They tried to reconcile it. But we don't believe that because we don't have a contract, we could go to the Court of Federal Claims. And then secondly, and more significantly,
Can you just tell me what I would look to understand the Tucker Act to demand privity? Right? What Court of Federal Claims case or Federal Circuit case or what would I look at to understand Tucker Act require privity?
I'm sorry, Your Honor. I'll call your attention to Todd versus United States in the Federal Circuit. Consequently, appellants do not have a contract with the United States and cannot base a claim for money damages against the United States on a contract to which they are not a party. That's a Federal Circuit case cited in our brief. This very same line was recently adjudicated in the AAUP versus Trump case in California. The Tucker Act is inapplicable for the additional reason that plaintiffs cannot bring a contract claim as non-parties to the grant agreements. Under the Tucker Act, the Court of Federal Claims has jurisdiction only if there is privity of contract between plaintiffs and the government. When no such privity exists between plaintiffs and the government, the Court of Federal Claims jurisdiction does not cover the dispute. So again, Your Honor, the nature of these grants take this case out of the jurisdiction of the Court of Federal Claims. And then also significantly, the Court of Federal Claims cannot provide the prospective injunctive relief. The Bowen case itself says the Court of Federal Claims does not have general equitable powers of a district court to grant prospective relief. We've stated categorically the CFC has no power to grant equitable relief. We are not willing to assume that a naked money judgment against the U.S. will always be an adequate substitute for prospective relief fashioned in the light of the rather complex ongoing relationship between the parties.
What equitable relief are you seeking here? We've said in recent cases that the fact that a party is seeking relief the Federal Circuit can't grant doesn't mean, or that the Court of Federal Claims can't grant doesn't mean that the claim doesn't belong there, right? Congress limited the remedies for breach of contract, and specific performance may not be allowed. Mm-hmm. But in those cases, grants had been canceled and parties were seeking specific performance of those grants. They wanted them reinstated. Here, what you're seeking seems different, right? That the terms of your contract have been changed because the federal government thinks your client's violating Title IX. So there's the dispute about whether you're violating Title IX and what the terms of that contract should be. That sort of relief, how does that play into that difference in relief? How does that play into the distinction between this case and our prior cases about this topic?
Your Honor, that is the crucial question, because what we are facing is essentially a sword of Damocles hanging over the heads of the school divisions. And we need judicial intervention to essentially remove the sword, right? What has happened here—
Well, you may or may not get judicial intervention, like maybe even the district court can't hear this because it's not right or something, I don't know. But the question is, like, where does it belong? Like, why would the Court of Federal Claims be the place to determine whether the federal government can add a condition to your contract or not?
Because, Your Honor, what it involves is not the terms of a contract. which is appropriate for adjudication in the Court of Federal Claims, but rather the substantive interpretation of Title IX and the Equal Protection Clause. That is appropriately, uniquely under the Administrative Procedures Act, a question for an Article III district court. This is not simply does the grant recipient abide by the terms of the grant. It is the department imposing an unlawful, unconstitutional condition upon those federal funds. That is why the nature of this dispute, it's not simply a dispute in contract, it is a substantive dispute about Title IX. And that is what separates this from Sustainability Institute and from the shadow docket cases. They did not involve that substantive disagreement as to the scope of Title IX. That is why we believe that sword hanging over our head can only be essentially resolved by a trial court, not the Court of Federal Claims, because of the fundamentally different nature of it.
Can I follow up on a point that Judge Rushing made regarding ripeness, which I know is not before us, but I think this implicates what has happened so far. You said that grants haven't been denied outright. Instead, the model has changed to require you to seek reimbursement as opposed to receiving advance payment. If that's the case, what relief could a district court provide if in fact that method of payment is left to the discretion of the agency, or do you disagree that that's an issue that we have no jurisdiction, or district court would have no jurisdiction over?
We would be seeking a declaratory judgment and an affirmation, Your Honor, by the district court that our interpretation of Title IX, consistent with this court's authority in Grimm and Doe, is correct, essentially removing the sword from over our head and the dilemma, the insoluble dilemma of violate Title IX to keep federal funds would be resolved. It is the equitable relief of a declaration affirming our interpretation, we think our clearly correct interpretation of Title IX preserves the federal funds. That is the relief that we seek.
All right, I'll ask my colleagues if they have any additional questions. Thank you very much. You have some time left for rebuttal.
Thank you.
Mr. Combley?
Thank you, Your Honor. The plaintiffs in this case rushed into federal court asking for a TRO because based on their thoughts, they were on the verge of, in their perspective, losing some funding. But they did it without establishing the jurisdiction of the federal district court. And the district court properly dismissed the case, and that order should stand. So I'm going to go a little bit out of order based on the questioning from the panel, my friend on the other side. I'll start with kind of the dual track argument and then get into why 1683 does not provide an end around to the Tucker Act, as well as the other grounds for relief. So one of the big things that defendants seem to shift over to, so first off, their argument that grants are not contracts, that's foreclosed by the recent Supreme Court precedent in Department of Education v. NIH, and NIH, and Sustainability Institute also forecloses that argument. So what it appears to be based on their 28J letter is this idea of potentially a dual track where the high risk designation could be reviewed in a federal district court versus any funding termination or issue regarding that potentially being in the Court of Federal Claims. And I have 5 things I want to highlight on that. So first, the reason that the dual track issue came up in the NIH case is because there was separate generally applicable policy guidance that preceded the termination letters in that case. So when you talk about, generally applicable guidance that applies to everyone versus the specific grant termination document, that's the reason that Justice Barrett talked about a dual track. Here, you don't have that. You have one letter.
I'm sorry. Sorry to interrupt you, but I guess I need to go back and look at that. But why would that matter? What's the distinction that's being made there?
Yes, Your Honor, because general policy guidance that agencies come out with, internal guidance, as Justice Barrett described it, that's generally challengeable under the APA. But she said that the resulting grant terminations, which was a separate document, it was a form letter that terminated the grant.
Well, isn't the general policy guidance here the sort of regulatory and statutory violations or alleged violations of Title IX, which apply to everybody? I mean, that's what the department's attempting to enforce.
No, Your Honor. Basically, the letter that plaintiffs challenge is a letter that says, we're putting you on this high-risk designation and adding a condition to your funding. So when you look at kind of the prayers for relief in regards to that, in plaintiff's complaint, it's one of the prayers for relief is, quote, require that defendants immediately pay to FCPS any funds that have been denied pursuant to defendant's August 19, 2025 letter, JA 39. So it looks towards what the essence of the claim is. And this court also addressed the issue in the Solutions for Hometown Care case, which came out right after Sustainability Institute, where there was a policy memorandum from the Secretary of Homeland Security, followed by a freeze letter, and then followed by a termination letter. This court concluded that all of that the dismissal for that was appropriate because they ultimately all went towards the grant termination. So we look towards why they're in court in the first place.
Can you, and again, I'll go back and look at NIH. Can you point me to the distinction that you claim Justice Barrett made in that case, or is it just your gloss on the language that's used?
So she did separate the policy guidance from the resulting grant terminations. And the way that the majority of the court's opinion kind of laid out the paragraphs of what they were enjoining in the district court order. And the paragraphs that talked about the underlying policy guidance was not stayed, but the resulting grant terminations were what was stayed. And this also kind of leads me to my next point about the prospective versus retrospective relief. So
I don't want to mess with your argument order because I know you said you'd get there, but talking about a dual track approach seems to assume that some part of this case belongs in the Court of Federal Claims, which, as I understand your argument, the part that belongs there would be any request for funds. But I am kind of stuck there because Title IX and the General Education Provisions Acts provide very specific routes for appealing decisions to terminate or withhold funds. I guess withhold when you still have a contract, right? There's still an open account between these parties. The grant hasn't been canceled. If the Department of Education withheld funds from these schools as part of this enforcement action, they could appeal that directly to us, right? That would go to the Court of Appeals.
So, Your Honor, there's two things if Your Honor is referencing 28 USC 1683.
Right, and 1234, right?
Yes, Your Honor.
Yeah.
So basically, the first sentence of 1683, which links to 1234G, refers to a completed action under, and yes, that would.
And that hasn't happened yet. We haven't gotten there, right? So this is a Title IX enforcement action, and the Secretary hasn't taken any of those more drastic steps of withholding funds or a cease and desist letter. But instead, she's taken, I think, what the statute calls any other action authorized by law. And then Title IX says any agency action that's pursuant to 1682 is subject to judicial review as otherwise provided by law for similar agency action. And so then the question is just, when the Secretary adds a condition like this onto grant funds because she thinks a school district is violating the law, where is judicial review for that, right? Because that as otherwise provided by law. Isn't that the question?
No, Your Honor, we don't believe that that's the question because that presupposes that the Title IX procedure is the only avenue that the Secretary has for dealing with those who engage in sex discrimination. There are.
No, she has other, it says any other action authorized by law, right? And so she has invoked 1226A1 and is imposing an additional condition because the department never cuts off funding, right? So there's this additional condition and attempting to get the school districts to work together. But it's a Title IX enforcement action, right? Isn't that what this is?
So, Your Honor, there is a separate process that's still going for 1682. And the way that I read 20 USC 1683, the first sentence contemplates the completion of the process where there is something that's withheld, that's ultimately a final determination. That process is still ongoing, so the first sentence wouldn't apply. It's the second sentence that plaintiffs here seek to utilize as a cause of action under the APA. And that is, so basically for an appellate court to have jurisdiction over the first part, which is, the completion of 1682, it would have to go through the agency administrative process.
Right. For the appellate court to have jurisdiction, there'd have to be a hearing by an AJ and all of that. But what I'm saying is that's what would happen if funds were withheld here. We're not at that point yet, but the Secretary has taken other action to enforce Title IX, to action short of withholding funds.
Right.
That's the context here, right?
Right. So in Sustainability Institute,
And the plaintiffs are asking for multiple different kinds of relief. Some of the relief they're asking for may eventually be relief the district court doesn't have jurisdiction to give, right? If it comes to, funds being withheld or grants being terminated. But why wouldn't the district court have jurisdiction over any part of this suit? I mean, what about the request to set aside the designation of the schools as high risk because they're violating Title IX?
Yes, Your Honor. So I do have a couple points on that. So one, the APA, going back to Sustainability Institute, one of the things that the lower court did is that it says they would prohibit the government from freezing, terminating, or otherwise interfering with the funding of grants. So when you look at those conditions, interfering with the grants, that includes conditions as well. And that's what Sustainability Institute said a district court cannot do either.
But that's just not what happened in Sustainability Institute. Their grants have been completely canceled, and they wanted specific performance to reinstate those grants and pay them. It's hard for me to imagine going to the Court of Federal Claims if your only claim is, we're not violating Title IX, please make them remove this term from our contract. Like, imagine maybe they overstated their case by claiming that this was about money that's actually not been withheld from them. But imagine that's their only claim, is we're not violating Title IX, we're not high risk, remove this from our contract. You're saying that case goes to the Court of Federal Claims?
Yes, Your Honor. So one reason for that is the Court of Federal Claims can issue limited injunctive relief, which is prospective in nature, if it's designed to fully effectuate the payment of the money. So 28 U.S.C. 1491A2 states that, quote, to provide an entire remedy and to complete relief afforded by a judgment, the court may, and it goes on to say, issue orders directing, and then what's applicable here, corrections of applicable records, and such orders may be issued to any appropriate officials of the United States.
So you're saying that's exclusive jurisdiction. No other court in the country has jurisdiction over a case about whether the school district is violating Title IX and is therefore high risk, because the Court of Federal Claims has exclusive jurisdiction over that subject matter.
So, Your Honor, if it's because the reason that they're in court in the first place is because the high risk status doesn't allow them to get their payments on time. If you take that away, they wouldn't have been in court. And when you look at the reasons that they were seeking a TRO or a preliminary injunction, it was because they were believing that they were going to have funding withheld. So it goes back to what the essence of the contract is, where the source of the rights are. And I think we're in agreement that the source of the right to get paid on time comes from the grants themselves. And then the relief that they're seeking is ultimately to get paid on time, which is much different. And then even if you can separate the high risk designation from the repayment status, it runs into another problem that Justice Baird also flagged in the NIH case, which is that it would be tough to describe that as final agency action subject to the APA. And the APA...
Right, and there might be, I mean, for all I know, the Secretary has discretion to add these terms, and a court can't, there's nothing for a court to do about that, there's no standards for us to apply to say that a particular school district is or isn't high risk. I don't know. But that's not an argument that the Court of Federal Claims has exclusive jurisdiction. That's an argument that the district court once it exercises its jurisdiction, should look at that question and determine that maybe it can't go further with the case.
So, Your Honor, that's we still believe that the claim is ultimately boils down to money because the high risk designation is tied to the repayment status. So,
Can I ask why you're focused on the question about whether it's money as opposed to the Tucker Act, whether it's founded on the contract? I mean, I sort of thought the move that you would make would be to say it's founded on contract.
Yes.
Because they're trying to adjust the terms of the grant, which we treat as a contract.
That's
If
precisely
instead the secretary had done some other action unrelated to the grant with respect to finding a violation of Title IX, that would obviously be within the district court's authority, right? If it imposed some financial penalty or the like under 1682, but when the action taken is founded on contract, then it's the CFC's exclusive jurisdiction.
that is correct, Your Honor, and that is another point that I was going to raise, which is that it ultimately goes towards the secretary adding an additional contract from the plaintiff's perspective that wasn't already there, and the result is them not getting paid on time. So that's when you go towards what the source of the grant right is and what the relief that they're seeking. And the other
Counsel, I'm sorry to interrupt, but your colleague on the other side, I think, read off a litany of cases in the Federal Circuit where that result was foreclosed. Can you point to any case where, on these facts, where the Court of Federal Claims had exclusive jurisdiction and that was affirmed?
So, Your Honor, under 1683, I'm not aware of any cases that hit the Federal Circuit since these types of actions are a little bit rare. But what I can point to is that the CFC does have the ability to issue limited injunctive relief to.
But why? So you keep going back to that. Why does that matter? I mean, it seems like Sustainability Institute and its, citation to this Pachak case, the Indian case from Justice Kagan says, listen, if it's CFC and they don't have injunctive relief authority, that's totally fine, right? That includes the exceptions to the remedies. Like, maybe that's true, maybe it's not, but that seems sort of antecedent and unimportant.
Yes, Your Honor.
If it is sort of back to this question of, is the claim founded on contract when it's attempting to add a contractual term, or is it not founded on contract for some other reason? But ultimately the question is the claim they're making founded on contract? And here, this is not sort of an enforcement action per se, but is instead, a modification of the grant. And that modification of the grant is founded on contract.
Yes, that's correct. Basically, there is an extra term that and the reason that we don't believe that this particular action qualifies as an enforcement action is because the secretary is using a separate authority to set the terms of payment, which does result in a change of condition on the grant. And that's ultimately why.
I just want to understand what the department thinks this is, that the letters before adding the term made clear this is a Title IX enforcement action. And then the letters imposing the new term said, if you don't change your ways, we'll move on to more aggressive Title IX enforcement actions. I mean, they cited, 1682, 1683, like these, we can withhold funds, we can issue a cease and desist letter. So why isn't it, you said it's not a Title IX enforcement action because she decided to do something short of those remedies?
Yes, Your Honor. And typically when we talk about other means as allowed by law, that's typically an instance where they refer it to the Justice Department for an affirmative Title IX case, and that's how.
Not typically, that's one option. It says, among other things. That's one illustration of something else the secretary can do, but I'm sure you wouldn't want to argue the secretary is limited to only certain means when the statute seems to give her broad discretion in her options of ways to enforce this law, right?
So, Your Honor, those are two separate things. So the 1682 process is still ongoing, but the secretary took separate action under the different statutory provision. which is what 1226A1 is. But the main issue is whether that has the effect that's contractual in nature. And one of the reasons why it's important is because the second sentence that talks about when someone has a cause of action under the APA, it requires either a termination, refusal to grant, or refusal to continue federal assistance. That's
Well, you're right about that, but the other agency action, especially in the General Education Provisions Act, is left, there's no discussion of how that's reviewable, right? So usually the APA fills in the gap, right? So it's, if anything, the APA is the gap filler here. And then we're just back to the argument about, well, is the Tucker Act providing exclusive jurisdiction that muscles out the APA here?
So, Your Honor, we don't believe that the APA is a gap filler because when you read all the Tucker Act statutes as far as when a claim is in contract with the United States, it effectively gives the Court of Federal Claims exclusive jurisdiction over claims that are more than $10,000 against the United States. And it's also important because if Congress intended to remove Tucker Act jurisdiction for this specific type of contractual claim, it would have done so explicitly. And here, the judicial, it just says for actions not otherwise subject to judicial review. And in Horn versus Department of Agriculture, the Supreme Court noted, for instance, that the Agricultural Marketing Act of 1937 explicitly names the district court as the venue for takings claims against the USDA and thus withdraws Tucker Act jurisdiction affirmatively. 1683 does not contain any provision. So the idea would be that Congress doesn't override itself sub silentio. Congress knows how to channel things to a particular court. And when they use the term not otherwise subject to judicial review and then require the particular grant terminations or refusal to grant or continue federal assistance, those are the requirements for an APA action. And here, all you have is an APA action and as plaintiffs claim under 1683. And 1683 is triggered either when you have a final action that withdraws funds under 1682, which subjects it to a hearing within the agency and then the appellate court, or an APA cause of action that's when you have the factors met not otherwise subject to judicial review, or and the termination, refusal to grant or continue financial assistance, which this would not fit into. And as the plaintiffs bringing the case, they have the burden of demonstrating the subject matter jurisdiction of the court. And I see my time is running out, but I'm happy to answer any questions if the panel has any.
I'll ask my colleagues if they have any others. Thank you very much. Mr. Hafey, you've got some rebuttal time.
Thank you, Your Honor. I want to start with Judge Richardson's question, the crucial question, which whether or not this is a claim founded on contract or not, right? The court in Sustainability Institute and Solutions for Homegrown Connections cited the Megapulse case, the DC Circuit case, the determinative jurisdictional question, whether a plaintiff's claim is at its essence contractual. And it looks to two things, the Megapulse test, the source of rights upon which the plaintiff bases its claims. And
Stop on that one. The basis for you getting money, reimbursement, non-reimbursement, advance, is all the grant, right? I mean, for that piece of Megapulse, right, like it's the grant that is providing it. I understand you have an argument that the grant's not a contract, but I think given the precedent, that's a very hard argument for you.
Set aside, Your Honor, that a grant isn't a contract. No, the underlying source here is Title IX. Again, there's no dispute that the...
Wait, why does Title IX give you money, right? Title IX doesn't direct whether you get reimbursement or non-reimbursement, right? Or you get money at all. Like, that's the grant.
Yes, Your Honor, the grant does, but the interruption of the grant, the sole basis for that is the Department of Education's incorrect view that the divisions violate Title IX. That makes the source of the dispute Title IX, not the grant. There's no question about the terms of the grant. There's no allegation that Fairfax or Arlington have been in any way in violation of that other than this policy, which the department alleges violates Title IX. So the source...
Right, but that's the justification. So the government's action here, the department's action is to add terms to the grant, right? To make it more onerous.
Yes.
Right? and their justification might be Title IX, but what they're doing is, in your view, making the grant more onerous. But that means that the claim is founded upon the grant, right? The grant is the source of what we're doing. The justification might well be some other statute, right? This is a similar argument was made in DOE and NIH, that the conflict was with the statute. But what the court says is this still founded upon the grant.
Yeah, Your Honor, it's just a question of sort of what source of rights means. The way I read that provision of the Megapulse case, it's not that every case involving a grant has to go to the Court of Federal Claims. That would essentially render 1683 a nullity. 1683 says that APA is the appropriate forum for any agency action taken that terminates or refuses to grant or continue assistance. Under that absolutist reading of that first prong of Megapulse, that would essentially mean there's never APA relief. And
No, because the refusal to grant or to re-up this, that would not be founded upon a grant that exists, right? The refusal to give a grant is not founded upon a grant, right? It's once the grant is given and you're trying to mess with it that makes it founded upon the grant itself.
Your Honor, yes, again, there's no question that the grant itself gives rise to the ultimate school nutrition funding and special education funding, which is threatened. But the reason it's threatened, again, and I source of rights under Megapulse is Title IX. Again, that fundamental policy dispute. And the type of relief sought, the second prong of Megapulse, is not the repayment of grants, because again, thankfully that money has not yet been withheld. It's the prospective determination of whether Title IX does or does not protect our policy. So under the Megapulse test relied upon by this court in those two recent cases, we believe that compels APA review here and separates this from the Court of Federal Claims. The other thing that separates this case is what Judge Rushing was putting her finger on, which is we have a jurisdictional provision, a direct provision, which says in matters of Title IX, the APA is appropriate when there is the threatened termination of federal funds. And otherwise, Judge Alston relied upon the provision of 1683 that says unless judicial review is otherwise available. As I have articulated previously, we don't believe that we have otherwise available relief because the case is not appropriate for the Court of Federal Claims. Again, Your Honor, it is not appropriate for the Court of Federal Claims because that sword has not fallen. We have not yet suffered the remedy. We're simply seeking the removal of that sword, a judicial determination that our interpretation of Title IX is consistent with law. I see my time.
Can I just ask one follow-up to that? Just help me understand. I mean, you might characterize what you're asking for by declaration or otherwise as sort of a reformation of the grant, right? Like make them take away this high-risk provision, and just help me understand why you think that is not founded upon the grant, but is instead, I think you would say, founded upon Title IX?
Yes. Your Honor, again, the terms of the grant have never changed. We were applying this policy for years under the school nutrition program, Title I, and that was viewed as completely consistent with law. But what has changed is that the new Department of Education has changed its position on Title IX. That's the only thing that's changed. The contract itself, the grant, has not. So what we're seeking is adjudication of whether our adherence to Grimm and to Doe and to the clear precedent of this court is or is not correct. That is a substantive claim that under 1683 and the APA belongs in district court.
All right, thank you.
Yes, Your Honor. Thank you very, very much for your time and attention. We appreciate it.
I want to thank both counsel for their fine arguments here this morning. As you know, by tradition, we typically come down from the bench and greet you. We can't do that, obviously, given where we are, but nonetheless, we really appreciate your being with us today remotely and appreciate your fine representation of your clients in this matter. With that, we'll move on to our second case.
Thank you, Your Honors.
Michelle, Alyssa.
Colin, it looks like we're ready to go. Is that right?
Yes, Your Honor.
All right. Our second case is 25-1490 and 25-1501, Baramoff versus American Credit Acceptance, and the second case involving a credit union whose name's not in front of you at the moment. But Mr. Bacon, whenever you're ready.
Yes, good morning. May it please the court. My name is Jim Bacon, and I represent the appellants Elshan Baramoff and Babka Baramoff. If it's acceptable to the court, I'd like to reserve 5 minutes for rebuttal.
Yes.
This appeal challenges dismissal of the appellant's adversary proceedings on the theory that they lack standing because their claims are supposedly derivative. And the case is about whether individual guarantors, the equity holders, can categorically be locked out at the threshold, even where they plead direct, particularized injuries and claims that the debtor itself could not have asserted. So if standing is denied, then whenever a lender's misconduct also harms the debtor, then those third parties, like the appellants here, who are uniquely targeted by this misconduct, they become remediless whenever a bankruptcy intervenes. So standing is reviewed de novo, and whether a claim is property of the estate is a legal question also reviewed de novo. And at the pleading stage, the court doesn't resolve any merits or disputes or weighs contested facts. The question is whether the complaint plausibly pleads direct injury sufficient for standing. And the appellant's personal guarantee exposure, personal litigation burdens, and reputational harm alleged in their complaints are not injuries that the debtor could sue for. And they're not shared across the entire creditor body under 7 Cs. So what does that tell us? Third parties like the appellants who have standing where claims allege direct injury that is personal to them is not a mere reflection of harm to the debtor. I know the court asked us to talk about the Scott case, and I'm happy to go right to that right now and tell you why.
Can you start instead with identifying with some particularity what you believe, pick whichever one you like, what you believe the claim is that is not derivative? You talked a little bit about the injuries
Yes.
that you claim are personal, but we asked the question of, an injury might be relevant, but we asked the question of whether the claim is derivative or not. What is the claim or claims, if you want to talk about more than one, that you think are not derivative? I mean, the complaint, and obviously this isn't your fault, the complaint's not a model of clarity.
Yes, Your Honor, and part of our request is not only for reversal, but for remanding and leave to amend. So let me get to the specific claims. The claims that the appellants have asserted are personal guarantee exposure. I would ask the court to look at Joint Appendix, the two complaints. The first is Joint Appendix 13 to 21. And the second was Joint Appendix 14 to 44. Those are the two complaints. And I would cite the paragraphs that relate to
But
the
guarantee exposure is not a claim, right? That might be an injury, but it's not a claim, right? You don't bring a claim for guarantee exposure. What is the claim that you're asserting?
The claim is the inducing misrepresentation that is asserted in the 1490 case at
So
paragraph.
can I just ask like a specific question about one claim?
Sure.
So one of the complaints has a claim for quiet title. Are the plaintiffs claiming that they own the sales contracts? Or are they claiming that the company owns the sales contracts?
No, they're claiming that they have sustained personal injuries as a result of the,
No, I want to just talk about the claim, not the injuries.
okay,
So quiet title is a dispute between two people who both are claiming title to something usually, right? And a plaintiff sues for quiet title to say, take the liens off, or let's clarify who owns this property, right? So somebody, a plaintiff is claiming somebody has title and they want the title clear. Who are the plaintiffs claiming has title to these installment sales contracts?
the plaintiffs, I believe, not artfully written, but they are asserting that their, the claims are the contracts are the estates, but as to their personal damage and the claims that they are bringing independent, the claim.
So if the quiet title cause of action, and I'm legitimately asking because it wasn't clear, right? If the complaint seems to say they own it, but then they said to the district court or to the bankruptcy court, TAP owns it. If they're saying the debtor, the estate owns it, then that's a derivative claim, right? That's a claim on behalf of the quiet title on behalf of the debtor. But if they're saying we own it, then the plaintiffs own it, then that's a claim that the trustee wouldn't bring on behalf of the debtor, right? That would be sort of a conflicting claim. I'm just trying to sort out
Yes.
the answer to Judge Richardson's question, like going claim by claim, which ones do you say aren't derivative and why?
Okay, well, the allegations, I can refer to the paragraphs. They have asserted a number of different kinds of claims, but the case was dismissed under a 12B1. They have no standing at the threshold to assert any personal claims. And we're arguing that they do have standing because they have personal claims asserted in the complaint at paragraphs on 1490, 18, 19, 21, 24, 33, and 38. And in 1501, the introduction, and again, it's not a model of clarity.
Wait, I'm sorry, I didn't understand those numbers. So,
Okay.
so I'm at JA 20, and there are two claims, count 1 and count 2. Right? We talked about count 2. Can you just describe for me why you think count 1 is personal? The claim. I understand your injury suggestions, right? But I want to talk about the claim. What about determination of validity and extent of the lien is personal to your clients? Just articulate it for me.
That is not.
Okay.
All
right, good.
What the allegation is saying is that there has been a reputational harm, a personal litigation burden exposure, and that there has
Can you go to 37 and tell me what you think is personal about count 1, which is breach of fiduciary duty?
You say 37, you mean joint appendix page 37?
That's correct.
I'm getting there. I'm there. Okay.
Do you believe the fiduciary duty is personal and distinct to your client as opposed to may be owed to your client as a shareholder of TAF. That's what I'm trying to understand.
Okay, so what I think we have here is under the, I believe the Tempway case, an issue that says the claims relating to breach of fiduciary duty require control and require misrepresentation. And I think there can be a claim asserted for that coercive control and that wrongdoing. We're not saying that there needs to be a fiduciary duty rule articulated, but what we're saying is there are facts that could, if proven and if established, can support a personal claim by the appellants.
Okay, how about I understand your position there. On J38, can you tell me what's personal about the negligence claim? I just want to make sure I understand the argument that you're making for each of these claims. And you know, you didn't draft the complaint, you got what you got, right? But I'm just trying to understand what your argument is with respect to each of these claims.
I will tell you that the labeling, this is not a labeling issue. I think we should look at the actual underlying pleading. The pleading is we had been induced to sign on these personal guarantees. We were targeted. We've been misrepresented. Whether that was a negligence labeling or some other labeling, I'm not wedded to that. What I'm trying to say is these are very specific personal guarantee exposures from the wrongdoing that has been alleged, personal litigation burdens, and reputational harm, whether we call it negligence, breach of fiduciary duty, or any other label in this joint appendix. The key is have these appellants asserted claims personally. And I hope it's not lost on the court that the appellee's brief spends the last third arguing, and I'm saying presuming, the claims, the personal claims, are so poorly written and so defective, the court should ignore a remand and a reversal and should not send the case back, which in my view presumes that underlying that argument that these claims are so deficient, they have asserted personal claims that the trustee cannot assert. These are not claims that a trustee can vindicate. These claims, however they're labeled, if you look at them in substance, are claims that are personal to the appellants. And therefore, under the framework that we cited with 7Cs, the board case, Rivers, we have asserted properly at the threshold level, regardless of anything else after that, at the threshold level, standing for direct personal claims. I see my...
All right, thank you, Mr. Bacon. Mr. Foley?
Good morning, Honors. Appreciate the opportunity to present to the court. I'm going to be brief because I think the briefs have been very extensive. I will address at the outset the court's direction to be prepared to address the Scott versus National Century case, which I think is very relevant because it does talk about derivative standing, and I think that's what we're talking about in this case. Whether or not derivative standing exists in the Fourth Circuit, I know that was a question in the Scott case, but if it does, if derivative standing does exist in the Fourth Circuit like it does in some other circuits, what are the circumstances under which derivative standing is sought and or granted to a non-estate party, meaning a
Mr. Foley,
trustee.
I'm sorry to interrupt you so quickly, but my colleagues went through the complaint with your friend on the other side, Mr. Bacon, and pointed out that at least on the face of it, the claims appear not to be the kinds of, at least the labeling suggested that the claims do not appear to be the kind of personal claims that would be, that his clients could litigate without consent of the trustee. But putting aside the label, Mr. Bacon suggested that his client's beefs are with a guarantee or guarantees that ultimately would put his clients on the hook for any claims that might be vindicated by the trustee. Do you agree that if the trustee or any other party were to pursue his clients for the personal guarantee, that those are not derivative claims? Those are properly claims that they could defend?
Well, the guarantee that he's talking about is the guarantee that Mr. Bayermoff and his business colleague, gave to our client, the creditor. And we are pursuing collection action on those guarantees in the United States District Court in South Carolina. And that litigation has been pending for a while. I'm not involved in it, but we have summary judgment pending against Mr. Bayermoff on his guarantee in the United States District Court of South Carolina, and it's under advisement, and we're waiting for a ruling. There was a lot of procedural history, it's in the briefs, about what's going on in South Carolina. But to the extent that Mr. Bayermoff has any personal claims against my client, that's the place to bring them as a counterclaim or otherwise. I think he had tried a couple times and was not successful. But I think it's important to remember the history of this case. If I go back to the Scott analysis, the Scott case analysis, in that case, the owner who was running the debtor left the company on the eve of some renewal of a contract that was very important to the debtor. And in that case, there was a CRO, Chief Restructuring Officer, Charles Goldstein, who was running the estate. Similarly, in this case, that was after the CEO left. Similarly, in this case, at the outset, it's very important to remember that Mr. Bayermoff was removed from management of Total Auto Finance for malfeasance. We filed a motion to appoint a Chapter 11 trustee that was granted by the bankruptcy court judge for malfeasance by Mr. Bayermoff. And Jolene Wee, who's an independent third-party professional, has been appointed as the Chapter 11 trustee to liquidate the estate. And she has proceeded to market and liquidate the portfolio of retail installment sales contracts. That's been closed, that's been funded. Our client has received some payment down on principal. Our claim is around 27 million now, as opposed to 31 million. But the claims, to the extent any lender liability kind of claims exist, independent of the estate for Mr. Bayermoff, it doesn't belong anywhere near the bankruptcy court because we're not in bankruptcy, Mr. Bayermoff's not in bankruptcy, and if it doesn't affect the estate, which is what Mr. Bacon is arguing, it doesn't belong in bankruptcy court. We think the bankruptcy judge and the district court judge got it right on standing.
Can I ask a sort of specific question? If I squint and I'm looking at JA 20, I could read count 1 to talk about the determination of the extent of the lien, particularly in light of the last sentence in the prayer for relief, paragraph 1, to raise a claim for equitable subordination, right? Because in essence, what the court is, what the pro se plaintiff here was saying is that the plaintiffs had a significant cash investment, and therefore ACA's lien extends only after that initial investment. And so you might just rephrase that ever so slightly to say, my equity should come before the creditor's lien, right? That you could say is sort of an equitable subordination idea. If I read this complaint that liberally, can you respond to whether that is a derivative claim? And as I suspect, if it's not a derivative claim, why you think it's not a valid claim?
Yes, Your Honor. I think to the extent a complaint is filed in the bankruptcy court to determine the validity and priority extent of a secured creditor's lien, that can be litigated in the bankruptcy court. It's done all the time. But in this case, we obviously have some issues with Mr. Baramoff for the first year of the case, including schedules, including statements under oath on the 341 meeting, that he had no issue with the validity, extent, and scope of ACA's liens. That it was never raised. In fact, he's admitted.
But that's like a merits argument, right? So like what we have is a question of like, does he have standing to bring this claim, right? Is it a personal claim or is it a derivative claim? And if it's a claim for equitable subordination, it might fail 10 ways from Sunday, right? It probably does. But what it is a personal claim, because he's saying, as shareholder, I ought to get paid before the creditor. And that's a pretty unusual claim, but at least for standing purposes, it seems to be personal. Fair?
I would say the Chapter 11 trustee, since we're talking about liens on estate property, that it's in the purview of the Chapter 11 trustee to administer the estate, to determine the validity of claims, which is exactly what she's doing.
Yeah, but that's a little different, right? Because if the Chapter 11 trustee says, I think, just use creditors because it's easier, I think this creditor has priority against that over that creditor. Well, the subordinated creditor could bring a adversarial proceeding to say, no, equitable subordination, my subordinated claim ought to be higher in the process than this higher claim. And that's exactly what an adversarial proceeding would be. Nobody would think that this inferior subordinated creditor doesn't have standing to bring that subordination claim, because that claim is very personal to that creditor.
No, I agree with you, Judge Richardson, that if Mr. Baramoff was a creditor, which he is not, it has been found several times that he's not. He's an equity holder, and they come last in bankruptcy, as everybody knows. It's not a personal claim. I think it's an estate derivative claim based upon the priority scheme in the code as to how assets of a bankrupt entity are distributed.
Right, but there are at least some examples in sort of bankruptcy law where an equity holder has sought and been granted equitable subordination over a creditor. I mean, they're unusual, but it requires all sorts of bad faith, and I get it. But at least in theory, you could bring an equitable subordination claim as a equity holder seeking to subordinate a creditor's claim, right?
I agree, that is possible.
Okay, so except for a minute, hypothetically, that maybe they've pled such a thing, if they had pled such a thing, can you tell me why it's at least an invalid claim here? So if they had standing to bring an equitable subordination claim, what would your then response be to it?
Well, I think our response would be the judicial estoppel argument that we make in the papers, but also, more importantly...
Wait, so tell me that just to make sure, in the papers, you mean in the...
In the briefs.
Okay.
And is that in their response to the motion to dismiss at JA 286, there's a boldface heading that says plaintiffs are not seeking equitable subordination. Right. So they argue to the district court, don't read our complaint that way. That's not what we're seeking.
That is correct. That's what they said. It's hard. I know Mr. Bacon was not involved in the lower court proceedings, but it's been difficult to sort of interpret what we're dealing with, but I agree, this is not an equitable subordination complaint, and they disavow it. So, again, if we go back to the standards for derivative standing, which was never sought in this case, they never sought derivative standing. They could have. And the bankruptcy court could have gone through the analysis that the other circuits go through as to whether it's appropriate under certain strict controls, procedural safeguards, things of that like that are discussed in the Scott case. But that did not happen. And I think everything, the crux of Mr. Bayramoff's complaints have been since the beginning that he did not like being removed from control of collection of the portfolio. He thinks he can do it or did it better. He didn't like the fact that the Chapter 11 trustee hired as an estate professional, who he's now suing, Heritus, which is a collection firm that does collecting of retail and installment sales contracts, as an estate professional. Obviously, any malfeasance committed by Heritus is certainly an estate claim because the Chapter 11 trustee hired them. So if they did anything wrong, the estate would bring that claim against their own professional.
Can I ask you about, sorry to interrupt, can I ask you about one more specific claim? There is, I guess it's 2 claims for conspiracy to injure in trade or business. Why isn't that a personal claim rather than a derivative claim? My understanding of, at least the state cause of action, the statutory cause of action says a person who is injured in their business can bring a claim. That seems to be personal to the person who shows that they were injured in their business. Doesn't seem that the business could bring that claim. How is that derivative?
Well, I think in that context, you have to look at what the alleged injury is. And throughout all of this case, the alleged injury by Mr. Bayramoff is the devaluation of the portfolio based upon bad conduct by somebody, whether it's Heritus or my client. So if the injury relates to an estate asset and the claim is that somebody conspired to hurt the value of that asset, which down the road could hurt a shareholder if it was worth more money that reached shareholders. That's not the case here by a long shot, but I think that is still a derivative claim because there is no injury alleged, and there has never been an injury alleged by Mr. Bayramoff other than that the value of the portfolio was compromised by some bad acts by third parties. And I think that's an estate cause of action. And if the Chapter 11 trustee thought that we did something wrong to hurt an estate asset, she could sue us. She hasn't. She's administered the estate. She's evaluated our claim. There's no issue with, and again, Mr. Bayramoff has said many times in the record that he doesn't dispute the validity, part, and extent of our lien. Again, if he has some kind of a personal lender liability counterclaim against my client, that belongs in South Carolina in defending his liability on the guarantee because we're suing him there. But he hasn't raised it there. Well, he's tried, but I think the court there has denied his effort to amend his answer and counterclaims, which might explain why he filed these complaints in the bankruptcy court. I don't know.
Mr. Foley, to follow up on Judge Rushing's question about this conspiracy claim, I thought, and Mr. Bacon can correct me on rebuttal if I'm wrong, that he mentioned something about his clients suffering reputational injury, which would seem to me to be entirely personal to them, not an asset of the estate or claim of the estate. If that's the claim, is there a different result?
To the extent Mr. Bayramoff has his own personal reputation in the industry of subprime auto lending, then I would have to concede, Your Honor, that that would be a personal claim But that doesn't belong in the bankruptcy court, though. That's my whole point, is anything relating to the bankruptcy, if he's suffered reputational harm that's personal and not his business reputation, not the business that he was running, if his business reputation has been injured as an individual, the fact that he was removed from management of this company for malfeasance by a final order of a judge, federal judge, that might explain some of the reputational harm, but that's not us. We didn't do that.
So help me understand why, and you have to excuse somebody who is not a bankruptcy lawyer, but I understand your argument that that is not a bankruptcy matter. But can you walk me through why that's not a bankruptcy matter, why he can't bring that sort of claim in an adversary proceeding as opposed to the District of South Carolina? What prohibits him from bringing it as an adversary proceeding?
I don't think there would be related to jurisdiction for an adversary complaint in that regard that has no effect on the estate. It has to have, in order to have either core or non-core jurisdiction, there has to be some effect on the estate. And if it's a purely personal claim, then it has no effect on the estate. But here, every harm that Mr. Bearmuff has ever uttered relates to the estate's portfolio value and what it should be, what he thinks it is, what he thinks it should have been sold for, those kinds of things. It's not anything relating to a specific, I didn't get this next deal because my reputation was harmed by the activities of my client.
You have anything else, Mr. Foley?
I do not. Well, I'll just defer to the briefs. I think everything that we would argue is in there. I don't want to be repetitive. I'm certainly happy to address any other questions of the court.
All right, thank you very much. Mr. Bacon, you've got some rebuttal. You're on mute.
Thank you. Let me start first quickly with the claim that the appellants cannot bring this claim in the bankruptcy court. I didn't see that argument in any of the briefs. I didn't see any jurisdictional argument. What I saw was 1/3 of the last part of their brief argued that these personal claims are so poorly written, this court should not reverse and remand. That's the gist of what I read.
So can you tell me why, under your understanding of the bankruptcy code, you could bring as an adversarial proceeding a conspiracy to injure business for reputational harm against these two, ACA and Petrus? How is that related to the bankruptcy? Like what would the theoretical basis for adversarial proceedings be?
These parties were involved in securing a personal guarantee that, according to these allegations, were inducing misrepresentations to and coercing personal property from these individual appellants that is tied as a core proceeding to the underlying bankruptcy. They are all included in that. And as we cited in our briefs, we are entitled to go forward with that. I would also add, there was never any argument from the other side that somehow, some way, until we hear this, that those proceedings were barred for a lack of jurisdiction. And the court never got there and made any finding. The court simply said no standing. And we believe that was error. As to Judge Diaz's comment, I think that is 100% accurate. As to the argument that the plaintiff, or excuse me, the appellants.
Mr. Bacon, I'm sorry to interrupt you, but what comment did I make that you say was accurate? I'd like to know.
All of them, Chief, all of them.
Okay,
You
thank you for that.
You had asked, in the context of a conspiracy, whether that was personal.
Okay, got it.
Yes, Your Honor, and the first paragraph, Joint Appendix, page 14. Plaintiffs seek relief for severe financial, reputation, and emotional damages. I could go through the paragraphs. I've cited them. It's not the most articulately well-written brief, but I want to segue quickly over to the Scott case and point out some things that I think are important very, very quickly. This Scott case concerns standing of creditors to file adversary actions in bankruptcy court, asserting interests of the estate. And that's a quote from page 558 of the opinion. Scott does not address standing to assert personal injuries, which is what the appellants have. It does not address standing of guarantors to sue individually, which is what the appellants have. It does not address standing on non-derivative particularized harm, which is what the appellants assert. So the Fourth Circuit in Scott basically emphasized you can't commandeer estate litigation. We're not doing that. What we're doing, and if you compare, what we're saying is Scott governs derivative standing where creditors attempt to sue on behalf of the estate. That's not what we're doing. In Scott, creditors sue to protect the estate value. Opposing counsel argue that's what we're doing, but what the appellants are actually doing is asserting that they're individual guarantors that were personally induced to enter into those guarantees, and they gave away additional personal property. In Scott, the claims belong to the debtor. In the appellant's complaints, they're claiming these are our personal claims. So, there's a limitation. The Baramoff's claims cannot be brought or vindicated by the trustee. And if they're not permitted to bring their claims, their claims would be extinguished. And that violates the bankruptcy code, as we cited in our brief. So the other thing about Scott, and I just want to quote a sentence on page 563. It remains to be established whether Scott breached any fiduciary, contractual, or statutory duty. Such proceedings are currently ongoing. And then it's standing to do so is not before us in this appeal. So the Fourth Circuit expressly left open in bankruptcy court individual claims like this. So the trustee can't bring these claims. The appellants have asserted reputational harm, guarantor liability exposure, and fraud allegations that are personal. And as a result of that, we're asking the court to reverse and remand, and it would be helpful to clean up this complaint, leave to amend. And if there are any other questions, I'd be happy to answer.
All right, thank you very much, Mr. Bacon. I want to thank both counsel for their fine arguments this morning. We appreciate your being with us, even if remotely. Love to come greet you personally, but can't do that. But thank you again for being here. If my colleagues agree, we'll move on to our third case directly. Colin, looks like we're ready to go.
Yes, should be ready, Judge.
Thank you. Our third and final case this morning is 25-1347, Riley versus the United States Department of Labor. Mr. Small?
Good morning, Your Honors, and may it please the court. My name is Jacob Small, and I represent petitioner Keith Michael Riley. To begin, I'll offer a brief introduction and roadmap of my arguments today. Mr. Riley is a federal criminal investigator who exposed misconduct within the Department of Labor's Office of Inspector General. The board found by preponderant evidence that his disclosures were a contributing factor in the agency's decision to exclude him from employment. Despite that finding, the board let the agency escape, and that was error. Now, this case consolidates two MSPB appeal decisions. The first is Board Docket 0093, and it involves a vacancy from which Mr. Riley was excluded entirely. The second, Board Docket 0531, involves a vacancy for which he applied but was not selected. I will make 3 points this morning. First, on Board Docket 0093, the agency's decision fails at a threshold. Documents contradict its key testimony. Secondly, still on 0093, under the CAR factors, the agency cannot meet its clear and convincing burden. And third, I'll turn to docket 0531, the MSPB docket 0531, and argue that Mr. Riley exhausted his administrative remedies by giving OSC explicit written notification of whistleblower retaliation. Turning to my first point, that the agency's defense is contradicted by documentary evidence. The agency's relied on SAC Lisa Anderson's testimony that she used the same position description for a 2019 vacancy as for 2016 vacancies, and that's at JA 295. But the documents contradict her on that point. The 2016 vacancies said OIG wide at JA 1319 and 1320, and the 2019 vacancy says current employees only at JA 110. That change to current excludes former employees like Mr. Riley and is the basis of his appeal. Now, the record evidence shows a contradiction that the agency hasn't explained. When she testified that the same language is used, but the documents show that she didn't. Evidence that is contradicted by the agency's records cannot be clear and convincing under any standard.
Can I ask you about those two announcements, vacancy announcements? Were they both similar in the sense that the agency was trying to fill a short-term vacancy, and therefore it would seem logical that they would want to try to do so internally as opposed to going out to recruit a candidate?
If I understand, Your Honor, are you asking if the comparison announcements that we point to are similarly situated as the one at issue?
Yes.
I just don't know, Your Honor. What I do know is that when we turn to looking for comparators, the agency offered no comparators to show that they had done this before. So while I haven't looked to the record specifically to answer that question, and I just don't know it off the top of my head, I think that we would have expected that to have been part of the agency's discussion of the third CAR factor.
Well, I guess what I'm getting at, and you can respond to this, is that it on the face of it, it seems to make sense, and it doesn't seem to portend anything sinister that an agency might, for a short-term vacancy like this one, where they had someone go out on, I think it was medical leave, want to simply quickly, expeditiously get somebody from in-house as opposed to going out and solicit external candidates. So what's illogical or sinister about that?
Your Honor, and just correcting, I think that the individual in this case may have had a military posting that they had to attend.
Okay, you're right.
The argument is not internally consistent. If the asserted basis is that you want somebody who can rapidly get up and running and understands the agency, it would make sense to exclude people who'd never worked at the agency. It would not make sense to exclude people who had recent experience at the agency but had left. So we just think that if you're saying that if the agency says, and they do, that this is the reason why they take this particular action, we have to interrogate whether that solves the problem that they say that it does, or whether it's reasonable to expect it. And if the primary change is to remove the access to former OIG, to former employees of the same agency, I think that just on its face, it's an internally inconsistent argument, Your Honor. Did I
Okay.
address your question, Judge?
You did?
All right. I'm going to turn now to the second point that I plan to address today, which was the CAR factors. So under CAR, as the court's aware, the agency must satisfy 3 factors to meet its clear and convincing burden. We think it fails on all 3. Factor 1 is the strength of the agency's evidence. And the agency's evidence rests, as I discussed, on Anderson's testimony that she used the same language as 2016. And under Miller against DOJ, conclusory testimony alone is insufficient to meet the clear and convincing standard. And we think that based on the comparison of the documents, essentially the assertion by Anderson is reduced to a conclusory statement at that point. Similarly, under Smith against GSA, the question isn't whether limiting the vacancy was justified, it's whether the agency would have done it absent Mr. Riley's whistleblowing. And evidence contradicted by the agency's own records cannot answer that question. Turning to the second CAR factor, which is motive, we think that the board minimized this, treating Mr. Riley's complaints as not especially memorable, but we think 3 things demonstrate otherwise. First, look at who made the decisions. The same officials who denied Mr. Riley's reinstatement in January 2018, Garcia, Williams, and Anderson, were involved in restricting the January 2019 vacancy. That's JA 2612 and 2614. But we don't think that that's coincidence. We think that's a pattern. Second, Anderson, we think, got the date wrong in her affidavit. She claimed she spoke to Mr. Riley around March 2017. That's at JA 1536.
Do you make any of these factual arguments in your opening brief? Your opening brief didn't seem to include any of these disputes with the fact finding. All of this came up in your reply brief, isn't that right?
Your Honor, you asked me the question and I should know it, but at the moment I'm thinking that the argument we're making at the moment about the dates, I'd have to double check my briefs and I don't want to sort of get lost in my documents here. But taking you at your word that we excluded it from the initial brief, we think we offered it as rebuttal to the government's response.
Yeah, you mentioned the CAR factors as to this particular case in your opening brief, but I noticed it because I was surprised that you didn't take issue with any of the actual factual findings, and you didn't present these arguments about comparing a former opening announcement versus this one, or the dates and those sorts of things. And usually we expect your arguments to be in the opening brief or else be waived, because then your opponent can't respond to them.
Your Honor, to the extent that, and I saw that in the government's response that they made those arguments, I think that in our opening brief, we primarily take issue with the administrative judge's determination with respect to the CAR factors, that the government had met the CAR factors and that we had that they had appropriately put forward sufficient basis to overcome the contributing factor. When it comes to the government's allegation or argument in its response brief that we had failed to raise specific issues, and we tried to rebut those in our reply brief. So I hope that I address your question, Judge.
Sure, thanks.
Right. I was, I think, talking about the second CAR factor when you asked your question, Judge, and that leads me to discuss the third. The agency's response to the initial protected activity by Mr. Riley in this case, this is back in January 2017, that occurred the day after Mr. Riley's disclosures, when the Assistant Inspector General Garcia stripped him of his firearm and ordered a fitness exam. We think that it's still appropriate now for the court to notice that 24-hour time period as being especially close for reprisal purposes. And even though...
Let me ask you about that, Mr. Small, because the whole basis for that was your client's voluntary examination by his doctor and a conclusion that he was unfit for duty. I mean, what else were they supposed to do? That doesn't sound like retaliation. It sounds like an entirely appropriate response to a finding that he could no longer perform his job.
Well, my client's doctor did state for a time that he was not fit for duty, but the decision to force Mr. Riley into, or rather, the process by which he was moved into a negotiated retirement, disability retirement, was a multi-step process, and it culminates when his doctor clears him for duty and he seeks reinstatement. And at that point in time, there's and I don't think that this is especially apparent from the record from the record in the briefs, but it is in the JA. Mr. Riley's attorney asks for reinstatement, and the agency seems to shuffle him out the door really quickly to accomplish the OPM disability retirement. What we think, Your Honor, is that Mr. Riley's initial protected activity, where he's making complaints about his SAC and where he's trying to get relief, that was the modus for moving him out, for pushing him into retirement. And when he sought to have his retirement, when he sought for reinstatement and he came back and his attorney said that he thought that the process by which he had been pushed into the disability retirement was discriminatory, the agency summarily denied that. Now, none of those facts, none of that are before the court as a dispute today, but that's important context because we think it does help the court understand why later the agency is taking steps to keep Mr. Riley out of the agency when he tries to come back. I'll turn with the remaining time I have here and before rebuttal, I'll turn to the third point I plan to make, and that was that with respect to the AJ's determination that Mr. Riley had failed to exhaust, now talking about 0531, the other MSPB appeal. The board dismissed this claim after an initial finding at the jurisdictional level that he had exhausted his administrative remedies. The AJ revisited it. And noticing I've got very limited time here, I'll try to keep my discussion of this brief. The court should look to Mr. Riley's emailed communications to OSC, to investigator Angela Rush. There he included email attachments, including, I think that what's in our brief here, I think is it JA 1279, where he sends an email describing his concerns. We think that for those reasons, the AJ was wrong in revisiting and then overturning the initial jurisdictional finding that there was exhaustion. I see that my time is expiring, so unless the panel has any additional questions, I'll reserve for rebuttal.
All right, thank you very much, Ms. Kropp.
Good morning. May it please the court, my name is Molly Gropp. I'm here from the Department of Justice on behalf of Respondent Department of Labor. The Department of Labor respectfully requests that the court affirm the MSPB's denial of corrective action in 2 IRA appeals brought by Mr. Riley. On appeal, Mr. Riley is largely asking this court to relitigate facts that were found below by the board. As this court is aware, that's not the court's province, as set forth in this court's Michaela case and Pearson cases. Rather, the court reviews the record for substantial evidence, and we would submit that the board's 2 decisions are amply supported by substantial evidence in this case. I'd like to start, if I may, with vacancy 13 and then turn to vacancy 239. Just for clarity of the record, vacancy 13, which was also known as the 93 appeal, was an internal job posting. As a former employee, Mr. Riley was not in a position to apply for an internal posting. The board heard Mr. Riley's arguments below and ultimately found that the agency proved by clear and convincing evidence that its decision to list the vacancy as internal only was not in retaliation for any protected disclosures by Mr. Riley. Mr. Riley has argued in his briefs that the board's findings below, either that it had jurisdiction over the protected disclosures for vacancy 13, or that Mr. Riley had established a prima facie case, are somehow dispositive of the Carr factor analysis. They are not. The law is clear that under Carr, which this court has adopted and applied in Mikhailov, the burden then shifts to the agency who has an opportunity to rebut that finding, as it did in this case. The board recognized that there was strong evidence justifying the agency's decision to list the vacancy internally. There were contemporaneous documents of a unique and urgent business need. As already discussed, the individual who held the position normally had been recalled to active duty and would be gone for 12 months. So it was a temporary position only. There was no full-time equivalent position available. Thus, it was limited as an internal posting for somebody to simply be reassigned for the year. The board considered that it was logical to conclude by the agency that a current employee would be better equipped to step right in and get the ball rolling. Also notably, Zach Anderson, who was the selecting official, was not aware that Mr. Riley was no longer employed at that time. Now, Mr. Riley makes much of differences in wording in vacancy announcements prior to his January 2017 disclosures versus after, but we would submit that the differences in wording are distinctions without a difference. So prior to the January 2017 protected disclosures, we have vacancy announcements that are limited to OIG-wide and OIG nationwide, whereas after the disclosures, vacancy 13 is listed as current DOL OIG employees. That is the same thing. None of those vacancies cited by Mr. Riley were open to the public. At that time, Mr. Riley was a member of the public. The 2016 vacancies that are limited to applicants OIG-wide and OIG nationwide is another way of referring to current employees. So we would submit that the differences in the wordings are distinctions without a difference, and Zach Anderson was not making any false or erroneous statements in her explanations to the board.
I understood
Now,
Mr. Small to suggest that excluding, I suppose he would describe his client as a recent retiree or others similarly situated, doesn't seem to make operational sense, but that's not the test, I guess. It's whether or not there was anything untoward in limiting the announcement in the way that the agency did, right? Perhaps it might have been better, a better group of candidates, a wider array of candidates if recent retirees had been in the mix, but I don't think that's what the law requires.
That's correct, Your Honor. And also, just as a factual matter, there is a material financial difference for an agency in borrowing a position to be filled for 1 year on a temporary basis, right? That's no additional salary, it's no additional benefits. You're just borrowing an individual from elsewhere in the agency, like a detail, as opposed to creating a new position, which is what Mr. Riley argues he was entitled to. But again, that's not the standard. The agency possibly, if it had a full-time position, could have listed a full-time position, but it didn't have one. And the board found that Zach Anderson's testimony provided a fulsome explanation for why that vacancy 13 was limited to internal candidates. It was not a new position. It was going to be a temporary position for only 1 year. And even to fill that on a detail basis, they had to borrow a full-time equivalent position from another part of the Department of Labor. With respect to CAR Factor 2 for vacancy 13, the board found that there was minimal, if any, motive and thus considered the factor neutral in its CAR balancing analysis. The board acknowledged that Zach Anderson had knowledge of the January 2017 protected disclosures, although the board credited her explanation that she did not view them significant or remarkable enough to rise to abuse or mismanagement, that it was an interpersonal issue between Mr. Riley and his first-line supervisor. So in any event, to the extent the board recognized any retaliation, it was not based on affirmative evidence of Zach Anderson holding any retaliatory motive or bias. It was based on circumstantial evidence, which is allowed by the statute in this context, considering the knowledge and timing test. Basically, the selecting official Anderson here, had knowledge of the protected disclosures, and the decision to limit the vacancy announcement to internal only was made within 2 years of the protected disclosures. Therefore, a reasonable person could conclude there was retaliation, but that doesn't mean that there actually was as an affirmative factual matter, which is why with knowledge and timing, it was sufficient in terms of Mr. Riley's prima facie case of contributing factor, but when it got to the CAR factor 2 analysis, the board found it was not terribly strong evidence of retaliatory motive because there was nothing in the record that suggested Zach Anderson actually harbored any retaliatory animus or bias. Now, before the board had also considered Mr. Riley's cat's paw argument, what's known as a cat's paw, where one individual might harbor retaliatory animus and controls others. The board disregarded that argument and found it not supported by the record in this case. Mr. Riley does not raise the cat's paw argument in his opening brief before this court, though he mentions it without much development in his reply. We would submit under this court's precedent in Grayson that any challenge to the cat's paw analysis is waived. Finally, with respect to CAR factor 3, the court found the factor was neutral because there was no evidence of comparators. Mr. Riley submits that the absence of evidence should have been viewed as a basis for an adverse inference against the agency, or at least meant that the factor would then weigh in his favor, but the law is not on his side for this argument. The law is clear based on a progeny of cases, Whitmore, Seiler, Smith, Doyle, that the absence of evidence under CAR factor 3 cannot favor the government. And the board recognized that in this case in holding that the factor was neutral. But the absence of evidence does not mean that CAR factor 3 weighs against the agency. That's the Rickle case. CAR in and of itself does not require the agency to produce evidence under each and every one of the factors or to prevail under each and every one of the factors in order to establish clear and convincing evidence. It's a balancing test. And in this instance, the board we submit had substantial evidence to side with the government that the agency had established by clear and convincing evidence that there was no pretext in listing vacancy 13 as an internal posting only. If there are no questions on that vacancy announcement, I'll move on to 531. The second vacancy at issue is actually vacancy 239. That's variously referred to as Appeal 531. In that instance, it was a public posting for OIG and non-OIG or non-labor employees. Therefore, Mr. Riley could apply, but he was not selected. On appeal to the board found that he had failed to exhaust his administrative remedies with respect to vacancy 239, and in the alternative, even if he had exhausted, he had failed to establish a prima facie case that retaliation had been a contributing factor in his non-selection for that vacancy. We would submit again that the board's analysis is amply supported by substantial evidence and consistent with the record. The OSC complaint with respect to vacancy 239 appears in the record at JA 877 to 878. It is very clear on those pages that the only basis for corrective action Mr. Riley sought before the OSC with respect to vacancy 239 was unauthorized preference. He says his scores were artificially deflated and he wasn't credited for his work protection detail such that someone else got the job, essentially.
I think Mr. Small, Ms. Groff, Mr. Small if not expressly, at least implicitly concedes that the complaint might not have alerted the agency, but then he points to an email that he says does. What's deficient with respect to that?
Yes, Your Honor. So the specific OSC complaint for vacancy 239 is at 877 to 878. That is part of a larger packet that Mr. Riley submitted to the Office of Special Counsel that runs from 856 to 889, I believe. 859 to 886. In that packet, he includes other complaints about other vacancies, right? That's the blacklisting claims, other vacancies. Each complaint is its own standalone piece. They're just assembled together in a packet. And if you run through that packet, his requests for corrective action with respect to other vacancies talk about retaliation for whistleblowing. But the OSC complaint for vacancy 239 specifically does not. And so after OSC received this packet and ultimately sent emails and issued a letter closing the investigation, it refers to, closing out an investigation that included retaliation for whistleblowing, but that was a reference to the larger packet, not the OSC complaint at issue here, which is 239.
Well, I suppose we don't even need to deal with that if it's what you say, that the agency considered the claim nonetheless on the merits and rejected it, right?
The OSC closed what exactly the OSC did is not clear, but what they did was close the investigation and give Mr. Riley permission to file an appeal with the board. There's no investigatory record of OSC.
Well, I was referring to your alternative argument about contributing factor.
Yes, Your Honor. So even if this court were to disagree with the board that there was exhaustion, the board found in the alternative that Mr. Riley had not established a prima facie case for retaliation for whistleblowing with respect to vacancy 239. And the reasons for that are several-fold. So whereas for vacancy 13, Mr. Riley could rely on circumstantial evidence, the knowledge and timing test, that was not an option for him with respect to vacancy 239 because he could not establish either knowledge or timing. This vacancy announcement 239 was issued more than 2 years and 7 months after the purported protected disclosures in January 2017. So under at least the court's Federal Circuit's analysis, which we would submit as persuasive, that's too attenuated of a time to make an inference of retaliation like one could for vacancy 13. Also, the selecting official is different for vacancy 239. Zach Anderson, for the other vacancy, had knowledge of the January 2017 protected disclosures. The selecting official, Downey, in vacancy 239, did not and testified as such, and there's no evidence to the contrary on that. Now, Mr. Riley makes much of the fact that Downey, the selecting official for 239, was aware of other EEOC actions that had been filed by Mr. Riley, but he is not alleging retaliation for EEOC actions before the board or before this court. He has alleged retaliation for protected disclosures to the OSC in January 2017, and the record is clear that selecting official Downey did not have knowledge of that when the vacancy announcement was posted or when someone else was selected in lieu of Mr. Riley. So without the knowledge and timing test available, Mr. Riley has to rely on actual evidence of retaliatory bias or animus by the selecting official. And as I just explained, Mr. Downey did not have any knowledge of the OSC complaints from January 2017.
Well, Mrs. Small says that his ability to rebut any of that evidence was hampered by the fact that this panel selection members destroyed their notes and that should have resulted in adverse inference against the agency. I'm trying to remember what your response was to that. I think you said that this was just a standard practice. Do I have that right?
Yes, and I can elaborate that on that a bit. So the board did consider the spoliation argument. Mr. Riley made it before the board below, and the board rejected it. And we would submit that the board did not abuse its discretion in doing so. The record reflected that, yes, the notes surrounding the selection of a candidate for vacancy 239 were destroyed by the panel. But that was not, the board found that an adverse inference was not warranted because that destruction of notes was not unique to vacancy 239, right? It was not evidence of some kind of retaliation or attempt to hide, views with respect to Mr. Riley. Selecting panels like that for 239 had routinely destroyed notes after a selection was made, and they had done so based on advice from their human resources department. Now, albeit that advice was erroneous and inconsistent with OPM guidance, the board found that based on that explanation, there was no evidence of any kind of nefarious activity or nefarious motive in the destruction of the notes. But further in the alternative, to the extent it was inappropriate to have destroyed the notes, the board found that they considered it to be a harmless error because it was not anticipating that those notes would have held any kind of dispositive evidence of retaliation, because the individual selected to fill vacancy 239 had both more experience in protective services and more training than Mr. Riley. And so there was evidence in the record that supported that individual selection over Mr. Riley on the merits.
Do you have anything else, Ms. Kropp?
I do not, unless the panel has any questions.
All right, thank you very much.
Thank you.
Mr. Small?
Thank you, Your Honors. For rebuttal, I'll try to be brief. There's a few points that come to mind. The first is my friend on the other side's reference to the Rickle matter. It's true that Rickle does permit courts to find, or is an example of courts saying that the CAR factor 3 does not always need to be offered. But on the flip side of that is that CAR factors 1 and 2 would need to be especially strong. In Rickle, the deciding official, Captain Weiss, he had a weak motive, right? And here, the official who made the decision, S.A. Anderson, is the person who received Mr. Riley's whistleblowing complaints in 2018. If we just turn to the Marano against Department of Justice case, that's at 2 Fed 3rd, 1137, we notice that it's not merely the content of a protected disclosure that can be protected, it's the fact of a disclosure too. So here we know that S.A.C. Anderson knows about the fact of Mr. Riley's complaints. So we don't think that Rickle is carte blanche for courts to say that CAR factor 3 is no longer important. It is important, and when the other CAR factors don't weigh as heavily, you're not going to have the same result as in Rickle. I also want to just take this opportunity to point out that the way that the MSPB disposes of individual appeals at the jurisdictional level in a piecemeal fashion really has deprived Mr. Riley of the opportunity to make his core argument, which is that ever since he left the Department of Labor, he's not been able to find a way in. Through many, many postings, he's looked for an opportunity as a competent and experienced federal investigator who's been awarded for his efforts in federal criminal work, federal criminal law enforcement work. That by itself speaks volumes that he's not even able really to get an interview. And that's why we've brought at various times a continuum of discrimination and blacklisting claim. And in our opening brief, we do argue that the jurisdictional decision by the AJ to dismiss the blacklisting claim is an error. And so what I would just note is that while my friend on the other side is talking about us not having the ability to prove that in one of the remaining vacancy announcements that's left open, that individual decider knew about the protected activity in 2018. I will note that Daniel Downey did, I don't think that Daniel Downey's affidavit regarding the EEO issues are clear that he is only thinking of EEO complaints. I think he says that they've had to comply with investigatory steps every time Mr. Riley complains. So I don't think it's 100% clear that we can say that he's only thinking about EEO. I think that's a bit open to interpretation. But our primary argument when Mr. Riley brought these claims was that he's been barred from employment. And so if the court should look at the entirety of Mr. Riley's allegations and the blacklisting allegations, and whether that is to say that the blacklisting jurisdictional determination is in error and that it needs to go back so that that all of those claims can be sent for discovery and a hearing, or whether it's to say that that pattern of conduct is relevant to the question for 0531, for the 0531 appeal of whether there is contributing factor. We think that the blacklisting and the pattern of sort of barring him from employment are relevant. So with that, I'll answer any further questions the panel has. Otherwise, I thank you for your time.
All right. Thank you both, counsel, for your arguments this still morning. Thank you for being with us remotely. We appreciate your presence and help with this final case on our docket today. And with that, we'd ask the clerk to adjourn court until tomorrow morning at 9:30.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.